Advocacy at the National Health Law Program, Mara Youdelman, speaking to us today. So with that, I'm going to pass it over to Mara.
Thank you so much, Jorge. Thank you, CCHI, for sponsoring this webinar. I'm really excited to be with all of you. Jorge said you can get your notebooks out and your pens. I'm going to warn you, I'm going to be throwing a lot of information at you. As Jorge said, you will get a copy of the slides, so don't feel like you've got to write everything down, because there's a lot of really good information that I want to share. So again, I'm Mara Youdelman, we will let's get started. So if you're not familiar with the National Health Law Program, that's my day job. As Jorge said, I'm also a commissioner with the Certification Commission for Healthcare Interpreters. But NHELP, or the National Health Law Program, is a national nonprofit public interest law firm, and we work on improving access and quality of care for low-income and underserved populations. You can join our mailing list. We do a lot of work beyond 1557, what I'll be talking about today, but a lot of it is on health equity and access to care, so you might be interested in that as well. Okay, here's what we're going to go through today. And I'm going to warn you, I usually start by saying I have 3 strikes against me. So first, I'm a lawyer. Second, I'm a former New Yorker and I tend to talk fast. And third, I live and work inside the Beltway. So I'm going to try to not let those strikes affect you all today in getting the information that you need. But as I said, there's an awful lot that I think you want to know about. And so I will be talking for a while. And then, as Jorge said, I really hope we'll have some time for questions and answers. So here's the roadmap. I'm going to give you some background, just some level setting. What is Section 1557? How did we get to a 3rd set of regulations? Then I'll go through the final regulations, what's in there, and really focus on the language access requirements. I'll also talk a little bit about the enforcement of Section 1557, and then we'll go to some next steps and talk about your questions. All right, so let's get going. On May 6th of this year, the HHS Office for Civil Rights, or OCR, issued final regulations implementing Section 1557. This is the 3rd set of regulations. So first we had Obama regulations, then we had Trump regulations, now we have Biden regulations. Let's talk a little bit about what I mean when we're talking about Section 1557, the law, and 1557, the regulations. This is my legal bit, but I think it's really important that you all understand sort of what we're talking about and what it means when we say we're changing regulations, but actually the law stays the same. So first, as a bit of background, you all are probably really familiar with Title VI of the Civil Rights Act. If you take federal funds, you can't discriminate on the basis of race, color, or national origin. The Supreme Court and the Department of Health and Human Services said language can be a proxy for national origin. So what that means, if you take federal funds, you can't discriminate on the basis of race, color, that's how the statute reads, and language. Okay, so Title VI is still in effect. This was enacted back, as you see, 1964, still the law of the land. We also have regulations implementing Title VI, and we also have what some of you may know as the LEP guidance back from the early 2000s. As part of the Affordable Care Act, or the ACA, Congress included a broad non-discrimination protection. So this provision, and it's called Section 1557 because that's actually the section of the law, is it reinforces long-standing protections, as I said, to prohibit discrimination of what Title VI said. So race, color, national origin. It also prohibits discrimination against age from the Age Discrimination Act, disability from Section 504 of the Rehabilitation Act. And then for the first time, we also included in the Affordable Care Act protections from discrimination on the basis of sex in healthcare. Some of you might know about Title IX, which prevents sex discrimination in education. But before the Affordable Care Act was enacted, there was no protection from discrimination on the basis of sex in healthcare. One of the things that this final rule also recognizes is intersectionality, that you may come to a healthcare facility as a woman of color who's limited English proficient and has a disability. If you face discrimination, is it because of your sex, of your race, of your language, or of your disability? Before we had Section 1557, you may have different rights and protections based on each of those different factors. So you wouldn't be protected against sex discrimination. You would be protected against race discrimination and disability discrimination, but two different laws govern that. So the thing that the Affordable Care Act did is it brought all of these civil rights protections under one umbrella. And these regulations go a step farther and actually say, we recognize intersectionality. You may face discrimination because of a multitude of factors that you bring. The goal of Section 1357 was to bring those civil rights protections together, to say you have the same rights and you have the same relief or remedies or legal action, regardless of the type of discrimination that you're facing. All right, here's my little legal foray. Stay with me. I promise it's not going to be really intense. I want to talk a little bit about the hierarchy of law. First, we have something when someone usually says, okay, we've got a law, they're usually referring to a statute. This is what is passed by both houses of Congress, the House and the Senate, and then signed by the president, then actually becomes a law. So the Affordable Care Act is the law. Section 1557, if you look at the Affordable Care Act, is about 3 paragraphs in that law. You can't change a statute without enacting a new one. So despite the fact that I've just said we have had 3 sets of regulations, Section 1557, the law has remained the same. So it doesn't matter what those regulations say, you still couldn't discriminate, okay? Regulations, think of it as a little bit of a step down. You've got the statute, that's primary. Then you go down to regulations. These are often issued by federal agencies. You may have similar processes at your state level, but I'm talking about the federal level today. So the Department of Health and Human Services, Office for Civil Rights, takes these 3 paragraphs that we have in the Affordable Care Act and says, okay, what does it mean to not discriminate? What does this mean in practice? What does this mean in a hospital, in a clinic, in a public health department? And they will come out with regulations. They first come out in a proposed form. We submit public comments. They get finalized, which is what we're talking about today. And those regulations can't unilaterally be changed. If a new administration or even a current administration wants to change it, they have to go through that whole public process again. So put out a proposal, accept public comment, consider the public comment, then put out final regulations. Sometimes we also see guidance. That's sort of that 3rd step down. So we got statute, regulations, guidance. This is also developed by federal agencies. Usually there's not a public comment process, and an agency can change them a little bit more easily. What we might see, for example, as we move forward, is we might see like frequently asked questions. You say don't discriminate in telehealth in the regulation. What does that mean? Maybe the agency will answer some of those questions as we go forward. So if we look at what we're talking about today, Title VI is a statute. ACA Section 1557 is a statute. Regulations, I said we've had 3 sets on Section 1557. We also have Title VI regulations. Guidance, we have the HHS LEP guidance that was issued and finalized back in 2003. That still remains in effect. There's also a lot of documents on lep.gov, which can be guidance as well. Federal agency plans, federal guidances from other agencies, et cetera. One of the things to remember is Title VI applies to all federal funding. So we talk about it in the healthcare context, but if an entity gets funding from Department of Transportation, Department of Justice, Department of Education, they're also subject to Title VI, okay? If we look at Section 1557, that's limited to health programs or activities, okay? So it's not quite as broad Title VI, any federal funds. It's related only to health programs or activities, any part of which receives federal funding. It also goes a little bit further. So it says not only is it federal funding related to health programs and activities, but it's also any health program or activity administered by an executive agency or a federal agency, and any entity created under Title I of the Affordable Care Act. So in many ways, Section 1557 is broader than Title VI because it says also applies directly to federal agencies and to entities under Title I. But it's also a little bit narrower in that it only applies to health programs and activities. It doesn't say health programs and activities under the Department of Health and Human Services. So we'll be talking about HHS, but to the extent, for example, the Department of Veterans Affairs operates a health program. Department of Defense operates a health program for military members. The federal government offers health insurance to federal employees. All of those are actually also subject to Section 1557. So if we look in the healthcare arena, virtually every healthcare entity is going to be subject to Title VI and Section 1557 because they're taking federal funds. So if a hospital accepts Medicare and Medicaid patients, it's taking federal funds. If a public health department is getting funds to help with vaccine administration, if a community clinic is getting funds as a federally qualified health center, if an organization is getting money from the Centers for Disease Control or the National Institutes of Health to do research, all of those count as federal funds. It's very rare in the healthcare arena to have someone not take federal funds. Maybe concierge medicine at this point, where you're paying a provider, they don't take insurance, but virtually everyone in the healthcare arena is going to be subject to these federal laws. Okay, so talked a little bit about the background of Section 1557, talked about the difference between the statute and regulations. Let's actually get into the meat of what we're going to talk about today, these new final regulations. Okay, so they were issued by the Office for Civil Rights on May 6th. They changed the prior regulations. So again, I said first we had the Obama administration issued regulations 2016. Trump administration came in, changed and repealed a lot of those regulations in 2020. Now we've got new regulations that make a lot of changes. This slide sort of summarizes the changes outside of language access because I'm not going to be spending as much time. But given the fact that many of you are working in the healthcare arena and might be interpreting for patients, in a variety of settings or managing language services and disability services, I do want to make sure that you do understand that these regulations go beyond language access. So there's protections against discrimination on the basis of gender identity, sex stereotypes, pregnancy and related conditions, and sexual orientation. There's a pretty explicit definition section, so you can actually look in the regulations and get more details. There's requirements that entities have to have a Section 1557 compliance coordinator and written grievance procedures. Those two apply to entities that have 15 or more employees. Everyone has to train their staff. And then there's also provisions related to enforcement. Okay, so let's go through some of these definitions. Start talking about, again, sort of some of the broad terms, but also some of the more specific language access terms. So there are a lot of definitions in this definition section if you actually look in the regulations. They define a covered entity. So who's subject to these regulations? Again, for the most part, anyone taking federal funds, any federal agency or part of the Department of Health and Human Services that's operating a federal program or activity. So the federal government operates Medicare. They're subject to 1557. Federal government operates healthcare.gov. That's subject to Section 1557. It defines federal financial assistance. It defines a health program or activity, a recipient. It defines telehealth. Now I'm going to go through some of the language access definitions. And again, these are included in the regulations. And they're actually pretty broad. So there's definitions of terms: national origin, individual with limited English proficiency, language assistance services, new definitions for a relay interpreter, a new definition for a companion. If you look at the definition of language assistance services, it says it may include, so this is the floor, not a ceiling, may include, but this isn't, the be all end all list. It includes oral language assistance. It includes written translations. It includes written notice of availability. Again, this is the definition that's included in these regulations. And so anyone subject to Section 1557 regulations is going to comply. One more thing I should just specify, these regulations are coming out from the Department of Health and Human Services. So they only do apply to the programs and activities operated or funded by HHS. As I said, 1557, the statute, applies to health programs and activities across the entire federal government. But other agencies have not yet put out their own 1557 regulations. So we don't sort of have this level of detail for Department of Veterans Affairs or Department of Defense. Okay. What is, who can provide language services? This is obviously really important. And I know probably all of you on the call today certainly have examples in your own experience where someone is called in to interpret who really isn't trained as an interpreter, isn't qualified, isn't competent to be an interpreter. So the regulations define those who provide language services must be qualified. So the first definition is a qualified interpreter or a qualified translator for an individual with limited English proficiency. These are two separate definitions. I just combined them for the sake of efficiency because they're pretty parallel and to fit on one slide because I've already thrown a lot at you. So this sort of brings back and tweaks a bit the definition that's already been in regulations. So an individual has to demonstrate proficiency and speaking and understanding both spoken English and at least one other spoken language. Although there is a recognition in this rule now that says actually maybe it's 2 non-English languages if you're a relay interpreter. Second prong, you have to interpret or translate effectively, accurately, impartially, no specialized terminology, preserve the tone, the sentiment, the emotional level of the original oral statement. Third prong, demonstrate proficiency in and above, and sorry, I'm sorry, I repeated, it's so important to have that language proficiency that I have the bullet twice. So again, let's ignore the third bullet and say, so it's pretty much the same as the first, but then adheres to generally accepted interpreter ethics principles, including client confidentiality. So due to this definition, it's sort of implicit that not all interpreters can translate and not all translators can interpret because you might not be able to do the effectively, accurately, and impartially, etc. But I think it's really important to recognize that only individuals who can meet these standards would be determined qualified. We also have a definition of a qualified interpreter, actually, sorry, not translator, for an individual with a disability. The proposed rule had a definition for an interpreter for an individual with this disability that closely aligned to the Americans with Disabilities Act. We actually said, for consistency between those who help interpret for individuals with limited English proficiency and those who interpret for individuals with disabilities, we should recognize that the same standards should pretty much apply. So again, a sign language interpreter, for example, must know both English and the non-English language. It could be American Sign Language or another sign language. It could be another communication modality. So the regulation recognized as transliterators. Again, the second prong is the same. You need to interpret effectively, accurately, impartially. Third, adhere to generally accepted interpreter ethics. And then it says qualified interpreters can include, and again, this is for example, it's not an exhaustive list, sign language interpreters, oral transliterators, cued language and transliterators. Okay. We also have a definition of auxiliary aids and services. These are used by individuals with disabilities who may have communication challenges, may not actually use sign language or know sign language, but might need other assistance in ensuring effective communication. So there's a definition. And again, just because many of you are working in entities where you're or working in departments where you might be helping both individuals with limited English proficiency and individuals with disabilities, I wanted to make sure you sort of saw this as well. And again, this is not an exhaustive list. It's just an example of the types of assistance that individuals with disabilities may need to ensure effective communication. There's also a definition of qualified bilingual or multilingual staff. So these are individuals who are not going to serve as interpreters, but are going to provide services directly in a non-English language. So this has to be a member of the covered entity's workforce. They have to have designation in their job responsibility to serve in this role. And then they must be proficient in speaking and understanding English and a non-English spoken language. And again, be able to effectively, accurately, and impartially communicate. So, I think we've all had experiences where someone gets pulled in, from a hospital staff or from a clinic staff and is asked to assist or interpret. Just because someone's bilingual doesn't mean that they are qualified to interpret. And just because someone might be bilingual conversationally or have studied abroad in a foreign country or learned a language in high school or in college doesn't mean they're going to be competent to provide services directly in a non-English language. So again, I think this is a really important definition that we hopefully will be able to use to ensure that language services are competent and qualified and not just, sort of off the cuff using whoever you think might have sufficient language skills. This is something new for the Biden administration's 1557 regulations, was a definition of machine translation and an explanation of some of the limits of when it can be used. So machine translation or automated translation, we see this, a lot of times on websites. You may see a little widget on the top of a website that, implies that it will automatically translate that website into multiple languages, and people assume that translation is going to be accurate. Unfortunately, I think many of us know that that's not often the case, and that there often are a lot of errors because it's an automated translation. It's usually doing word for word translation. It's not capturing the essence of a sentence. It may not, have the concepts in place. I think one of the prime examples that we saw in recent years was, during COVID, when the vaccine was first becoming available. And so a lot of public health departments were putting information on their websites, in English saying, the vaccine's available, here's how to get it. It's important that you get it. It can help prevent disease. As one example, Virginia Department of Public Health used one of these widgets and automated translation software, and the Spanish translation implied that someone actually did not need a vaccine and it wouldn't be helpful. So it had the opposite public health messaging of what we wanted to use. So this regulation says that in certain circumstances, that automated translation or machine translation has to be reviewed by a qualified human translator. So we go back to that definition of who's a qualified translator for an individual with limited English proficiency. So this applies if the text that's being translated is critical to the rights, benefits, or meaningful access of a limited English proficient individual, when the accuracy is essential. So, maybe it's a prescription for medication. It's really essential that someone takes it at certain times of days and multiple times a day. Or when the source documents or materials contain complex, non-literal, or technical language. Think of an informed consent document in a hospital could be one of these examples. Okay, so I just saw the comment in the chat about when is accuracy not essential. Well, I think that's going to be one of those important issues to be looking at. And so to me, pretty much in the healthcare arena, pretty much accuracy is always essential. When you're trying to get a diagnosis, when you're trying to get someone's medical history, when you're trying to explain options for treatment or follow-up after surgery happens, all of those are pretty darn essential. So again, you can use this example and you can help educate those who you're working with or the facilities that you're working in about this new definition and about the importance of making sure it's accurate. Okay, so I went through a lot of the definitions, and I think we're speeding along and we're pretty good on time. So let's talk about some of the actual requirements beyond the definition sections that exist in these regulations. First, I talked a little bit about this before, but who do these regulations apply to? Again, it's anyone who receives federal financial assistance, health programs or activities operated by the federal government, or entities created under Title I of the Affordable Care Act, which is pretty much the marketplaces and all the qualified health plans that participate in those marketplaces. What this final regulation says also is that it applies to any health program or activity, any part of which is receiving federal financial assistance. So let's, for example, take a health insurer, and maybe it offers health plans on a marketplace, or maybe it offers managed care in Medicaid or Medicare. And it also offers employer-sponsored insurance outside of federal funding. Once these federal dollars touch that insurer, all of those insurers' activities are going to be covered and subject to Section 1557. This is a pretty significant change. It goes back to how the Obama administration interpreted Section 1557. And again, just because of the nature of how integrated a lot of our healthcare system is, this also means that virtually, that quite a lot of health insurance and healthcare is going to be covered by Section 1557. There's also a recognition in these regulations that actually not just the actual health care, what's happening in a clinic, in a physician's office, in a clinical office, in a hospital, but providing or administering health insurance is a health program or activity. So this gets to the fact that insurers are subject to these regulations, third-party administrators, short-term limited duration health insurance plan, pharmacy benefit managers, yes. Again, I'm sort of seeing a little bit in the chat on the side because I haven't opened, but if you do have questions, please remember to put them in the Q&A box. But someone asked about, like, does this mean it applies to like Kaiser, Altabates, UCSF, et cetera? It's hard for me to know without a lot more details, but once federal dollars start touching that, so if a hospital participates in the Medicare or the Medicaid program, Section 1557 applies to everything that happens in that hospital and every patient, not just those funded by Medicaid or Medicare. Now, if there's an employment issue, that's different. Different protections, different laws apply. So like if an employee feels they're facing discrimination, that's likely going to go to something like the Equal Employment Opportunity Commission and not Section 1557. But again, like what this means is virtually all the patient care, patient support, client support, if you're talking about a public health agency, an insurer's operations. Again, so if an insurer offers a Medicare Advantage plan, or offers a Medicaid managed care plan, or offers a marketplace plan, once they do that, yes, it means that all of their activities are going to be subject to 1557 for their health programs and activities. If that insurer also offers auto insurance, that's not going to be subject to this. So we're limited to health programs or activities and this federal financial assistance. So hopefully that answers that question. But I know I'm sure I'm missing a lot. So please put your questions in the Q&A where Jorge and Natalia are going to be able to track those. Okay, so getting back to some of the general requirements, and these apply more broadly than just related to language access. Any covered entity is going to have to develop specific policies and procedures, okay? This doesn't explicitly mean like a language access plan, but there's a lot of details in here about what that means. And so I'll go into that on, I think, a later slide. They have to disseminate a notice of non-discrimination and a separate notice of availability of language assistance services and auxiliary aids and services. And I'll talk more about that again as well. They have to designate a Section 1557 coordinator if it's an entity with 15 or more employees. And they have to develop grievance procedures. So individuals can file a grievance or a complaint, again, for entities with 15 or more employees, and then train their relevant staff. So let's go through most of these sort of a little bit more in detail. Okay, policies and procedures. So any covered entity must have written policies and procedures that comply with these regulations. These policies must include a non-discrimination policy, grievance policies, and specific language access procedures. Okay, so this is any size covered entity. They have to explain how employees identify whether someone's limited English proficient, how to obtain the services of a qualified interpreter or a translator, the names of qualified bilingual staff. If the entity uses bilingual staff, they don't have to, but if they are going to have some bilingual staff who are qualified to provide language services directly in a non-English language, they have to have them named in their policies and procedures. The list and location of electronic and written translated materials and the languages in their available. The policies also have effective communication procedures for persons with disabilities and reasonable modification procedures. Okay, so that's the policies and procedures. entities are also required to notify people of their non-discrimination policies. A lot of this really depends on, do people know what their rights are? Do entities know what their responsibilities are? How is this happening in practice? So the entities are responsible, again, these covered entities, those subject to these regulations, they have to notify the public of the entity's non-discrimination policy. Notify people how to request reasonable modifications. This is really for individuals with disabilities, how to get auxiliary aids and services, how to request materials in alternate formats. The notice of non-discrimination has to explain the language access services. So what electronic and translate and written documents are available. They have to say that oral interpreting is free of charge and available in a timely manner. Have to include contact information for the entity's 1557 coordinator, explain the grievance process, explain how to file a complaint with OCR, because sometimes the grievance process might not get the resolution an individual wants, and then how to access the covered entity's website. This notice of non-discrimination must be provided annually, on request, and be posted in clear and prominent physical locations, at least in a 20-point font. There's not an explicit requirement that this notice of non-discrimination be translated. So I just want to be clear about that. This is primarily an English notice. That said, there's a second requirement for a notice of the availability of language services and auxiliary aids and services. So some of you may remember under the Obama regulations, we had a requirement for taglines. Now we're going beyond taglines, recognizing that we not only have to inform limited English proficient individuals of their rights, but also people with disabilities what their rights are. So this notice has to be provided in English and at least the top 15 languages in the state. Again, it must be done annually, on request, on the website, and in a clear and prominent location, 20-point font, in alternative formats. There are still some tagline requirements in other regulations, but this really is sort of the one that's going to apply across the board in terms of this section 1557. Okay, so what does it mean? What documents do you have to send this with? Where does it have to appear? This is a list of documents in which this notice of availability of language services has to accompany. So when an entity sends out the notice of non-discrimination, they also have to send out this notice of availability. If they're sending out a notice saying you're not qualified for this program, or we're not giving you this service, they have to send this notice of availability and all of the documents on this page. So again, what we're hoping, once this rule is actually effective and implemented, that individuals with limited English proficiency will be able to be aware of what their rights are and how to request language services. So if they feel that that a decision was not made accurately or it was the wrong decision, they can request services, they can request assistance, and they can get interpreters, but also get assistance in taking next steps. Okay. So in terms of specifics about the language access policies and procedures, I went over this again a little bit before, but I really just want to re-emphasize it. The language access procedures have to include the contact information for the section 1557 coordinator, how to identify if someone has limited English proficiency, how to access the qualified interpreters and translators the entity uses, the names of qualified bilingual staff, and then the translated materials. And there's a similar requirement on policies and procedures related to communication and access to auxiliary aids and services for persons with disabilities. Okay, I mentioned that if an entity has 15 or more employees, it must have a section 1557 coordinator. So the entity has to designate and authorize at least one employee. They could have multiple ones. If a hospital has 6 hospitals across a city or a state, maybe it wants to have a section 1557 coordinator in each. It doesn't have to, but it could. The responsibilities of this coordinator are to receive, review, and process grievances, coordinate record keeping, coordinate effective implementation of language access and reasonable modifications, and coordinate the training. So again, the hope is that this is going to be housed in the responsibility of at least one individual to make sure that Section 1557 is implemented in the ways that it was intended. There's also a requirement for training staff. So the regulations say that entities must train relevant employees on these policies and procedures. The training has to be provided as soon as possible after someone is hired, but no later than, this is again because the regulation isn't quite yet effective, but no later than 30 days following the implementation of the policies and procedures. So basically, we're giving entities some time to develop their policies and procedures. After the policies and procedures are implemented, you've got to train staff on them. And then as they hire new staff, they're going to have to train their new staff. It also defines what a relevant employee is. So it includes both permanent and temporary employees. It includes those in public contact positions, but also those who are making the decisions. So executive leadership team and legal counsel, might be your risk management folks. It also includes training of those who perform the tasks and make decisions regarding financial obligations, including billing and collections. So we often hear that sometimes individuals, sorry, I just said often and sometimes. We sometimes hear that individuals with limited English proficiency aren't informed about charity care options or payment options when they get bills. Again, I think this regulation recognizes that and says you can't just train the staff who are maybe providing the care, but you also have to train staff who are doing the billing and financial obligations so that, again, hopefully individuals with limited English proficiency will get the same information and have the same options as those who are English proficient. Hang with me. I know I'm still throwing a lot at you. We're almost through some of the specifics, and then I'm going to get we're almost through with some of the general requirements of these rules, and then we'll dig in a little bit more on language access pieces. So I also mentioned that any entity with 15 or more individuals must have a written grievance procedure, and that 1557 coordinator is going to have to review any grievances that are filed. They also have to maintain their records for at least 3 years. And they have to keep the identity of an individual confidential unless there's some legal requirements related to that. Okay. Excuse me. Let's dig into some of the specifics on language access. So first, regarding limited English proficiency general, the focus is on the individual eligible to be served or likely to be served. You may remember from the HHS LEP guidance that there's a 4-factor test about, what's the resources of the entity, how often do they come into contact with LEP individuals. That's no longer here. What this says is you have to really look at the individual who's coming in your door or coming to your website or seeking services, and you have to take reasonable steps to provide meaningful access. What does that mean in practice? Well, if someone files a complaint with the Office for Civil Rights, OCR is going to look at these 2 main things. They're going to look at first, what's the nature and the importance of the health program or activity and the communication at issue? Someone said in the chat earlier, when is accuracy not essential? Well, if you're talking about giving healthcare, providing actually healthcare or information about access to healthcare, I'd say it's pretty much almost always important. And then OCR will also take into account other relevant factors, such as the effectiveness of language access policies. Language access has to be free of charge, accurate, timely, confidential, and cannot rely on staff other than these qualified interpreters, qualified translators, or qualified bilingual multilingual staff. What does that mean about using family members, friends, or minors, or others in a facility? Pretty much no. The regulation prohibits accompanying adults and minors except as a temporary measure in emergencies. And it basically says like imminent threat in these regulations while you're finding a qualified interpreter. You also can't rely on staff other than qualified bilingual or multilingual staff to communicate with individuals. If an individual brings someone with them and they say, I want my adult family member to interpret, that's okay if the limited English proficient individual agrees, the request in the agreement is documented, and the reliance is appropriate under the circumstances. What does that mean? Well, I'll give you two examples. If you're in a domestic violence situation, I'd say an accompanying adult, if that person is potentially the one committing the violence, would never be appropriate under the circumstances. Second, maybe the person starts acting as an interpreter, and it's pretty clear and obvious that that person is not interpreting everything, or is not maintaining the tone in the register, or doesn't know the medical terminology, or is summarizing or inserting their own values. I'd say that's also a situation where it's not going to be appropriate. Again, it's hard to define every factual situation on this one. But I think in general, what we've sort of seen as best practices is if someone says they want to use their own family member or accompanying person as an interpreter, that an entity probably still wants to have their own interpreter there to ensure the accuracy of the communication, the completeness of the communication, and be able to step in if it becomes clear that that accompanying adult is not competent to provide the language services. I often get asked a question about these regulations. Is there any requirement for translation? No, other than that notice of availability of language services. So there's no threshold, there's no requirement. The LEP guidance, which does still remain in effect, recommends translating vital documents, but there's nothing explicit that says you have to translate every document that a healthcare facility uses or an entity uses. There's also a provision in this regulation specifically focusing on artificial intelligence, and it says you can't discriminate in the use of a patient care decision support tool. So sometimes entities are using artificial intelligence in making clinical care diagnosis or determining who's eligible for certain services or certain procedures, or to determine prior authorization. Or as we saw during COVID, crisis standards of care. They're making decisions on who gets access to a ventilator and denying access to ventilators for people with disabilities, saying they might not live long enough. Discrimination is prohibited in all of those. So there's a specific provision talking about these patient care decision support tools. I would also say, though, that Section 1557 itself goes broader than that. So if there's artificial intelligence being used, for example, in an application or an eligibility system, discrimination would also be prohibited, even though that's not explicitly mentioned in these regulations at this time. The Office for Civil Rights did ask for comments on this provision and artificial intelligence in general. So folks, if you're seeing other examples, please let me know and I can get you information about how to submit comments. Another important provision in these regulations is for the first time, the administration sort of reinterpreted whether Medicare Part B is federal financial assistance. Up until these final regulations, and because of how Medicare Part B sort of was first implemented and how it was paid, and also because of, honestly, the racism in our society when Medicare was implemented, up until this year, Medicare Part B providers were not subject to Title VI or Section 1557. So brief sort of historical interlude. Medicare Part A is sort of hospital and inpatient services. Medicare Part B are outpatient services. So if you're going to a clinician's office or a clinic or getting services sort of not in an inpatient setting, that's covered by Medicare Part B. Way back in the 1960s, when Medicare was first enacted, for Medicare Part B, the federal government didn't actually pay the provider. They paid the enrollee, who then paid the provider. And Medicare didn't pay 100% of the costs. That was one of the reasons that HHS said, well, it's not really federal financial assistance because we're paying the enrollee, we're not paying the provider. And in large part, this was because certain doctors didn't want to have certain people in their waiting rooms. And so over the years, though, Medicare Part B payments changed. And now Medicare Part B and the federal government directly pays Medicare Part B providers. So it's been a long-standing effort by the National Health Law Program and some other partners to say Medicare Part B now operates no differently than any other federal financial assistance, and Title VI and Section 1557 and other civil rights laws should apply to Medicare Part B providers, and we've now seen that come into law. There's a couple other provisions that I just, sort of want to mention that folks are aware of. There's a provision preventing discrimination in telehealth. There's a provision talking about the basis of association. This really protects against discrimination for LGBTQ individuals and some others. You can't face discrimination based on who you associate with. And there's also some provisions in the regulations that put non-discrimination protections into regulations of other programs, specifically Medicaid, Children's Health Insurance Program, PACE, which is Program of All-Inclusive Care, and also the healthcare marketplaces. Okay, we're getting towards the final stretch here. I've got about 10 more slides to go, so soon you'll be able to ask your questions. So please, again, put them into the Q&A box. What does it mean to have these regulations, and what happens if you think you've been discriminated against? This is where enforcement comes into play. So there are specific procedures about how to file a complaint of discrimination. There's a slightly different procedure, whether it's a covered entity or whether it's a federal health program itself. But for the most part, it's really important to file complaints if you see violations of these provisions. You could file a complaint directly with the healthcare provider. Like I said, specifically if they have more than 15 employees, they have to have grievance procedures, and they have to have a coordinator who's going to be reviewing complaints and deciding what to do. Sometimes you can also file a complaint with your insurance commissioner, with an insurance company, with your Medicaid agency, but you also can file complaints with the Office for Civil Rights. For the most part, OCR will investigate any entity that it has oversight over. As I mentioned, other agencies don't yet have Section 1557 regulations. So if there was discrimination in the Veterans Affairs Health Program, you can't file a complaint with the Office for Civil Rights at HHS over that. You can file a complaint with Veterans Affairs. And then sometimes if it's an employment issue, as I mentioned earlier, it might go to the Equal Employment Opportunity Commission. But OCR, if it gets a complaint that it feels it doesn't have jurisdiction over, it will coordinate and send them on to the other relevant agencies. Complaints don't have to be filed by the individual actually facing discrimination. Certainly that individual can, but advocates can file on their behalf, healthcare providers can file, interpreters and translators can file, really anyone can file. And within the 180 days, the Office for Civil Rights, an individual has 180 days from when they knew of the discrimination to file a complaint. And again, on this slide, I include a link to the website where individuals can file complaints. Okay, so just to wrap up, I want to emphasize a couple key things. First, Title VI is still the law. Second, Section 1557 is still the law. So even though we've had 3 sets of regulations, and I really hope that this is the end, that statute still remains in effect. The HHS LEP guidance from 2003 is still in effect. The regulations that I have just walked you through are not yet in effect, but will be very shortly. So let's walk through some of the effective dates. And again, these are technicalities because when the federal government releases final regulations, it's not fair for them to be immediately effective. You've got to give folks time to make any changes they need to develop new policies and procedures. So in general, this entire rule will become effective around July 5th. So Section 1557 has been the law since March 23rd, 2010. We have 1557 regulations in place now from the Trump administration. These new regulations will start to go into effect on July 5th. There's a couple of exceptions for entities that are now sort of newly subject to these regulations. So for example, some of the insurers, if they're going to have to make changes to their plans or other health-related coverage, or they're now newly subject to these regulations because of how the definition worked, they're going to get a little bit more time to come into compliance. In terms of some of the specific policies or procedures that I've talked about, Section 1557 coordinators are going to have to be in place by November of this year. The same with that notice of non-discrimination. Covered entities are given a little bit longer, a year, to develop their policies and procedures, and then the notice of availability of language services. Training, I mentioned before. Again, entity is going to create the policies and procedures, and then they have to train on them. But again, the training should happen no later than May of 2025. And the piece on artificial intelligence also is going to get a little bit over a year until it becomes effective. Another important thing I just want to mention is some of your states actually have state laws that impact and have requirements for language access. Some of them may be Title VI or Section 1557 lookalike statutes. Some of them may apply to specific programs or activities. It really depends. We did a 50-state survey back in 2019, so you can take a look, see if something's another statute might be relevant or regulation in your state. Unfortunately, we haven't updated it since 2019 because of resources, but at least it could give you a starting out place. Finally, we've got a ton of resources on our website. So again, when you get this slide deck, and maybe we can post these into the chat, these are a bunch of resources. So our general website, our Section 1557 webpage, we did two analyses since this final rule came out. One was sort of, what's this rule as a whole? So looking at all the aspects of the rule and the requirements for non-discrimination broadly. And then secondly, we put out an issue brief that specifically looks at language access requirements under both Title VI and Section 1557. So this is an issue brief that's probably most relevant for a lot of the folks on this call. You can read it, you can share it, you can electronically send it, you can give it to entities that you're working with, whatever is most useful to help them understand the expectations and the requirements. And then we also did a couple of specific blogs on other aspects of the proposed rule. Okie doke. So I think I'm done talking at you. And now we can move into the questions. So I don't know,
Awesome.
Jorge or Natalia, I'm not sure, or Sean, who's actually facilitating that aspect.
I will take care of that, Mara. Thank you so much for for all of this amazing information. We've got a lot of questions in the Q&A, so I want to start off by with one that I think is on a lot of our minds. Can the ACA be eliminated by a future president? Is part one. Part two, I'm scrolling down to another question that is related. These are Biden administration regulations. Depending on the results of the election later this year, might we see new regulations after a public comment period with a new administration? And related question, while there must be a public comment period to change the regulations in the end, the administration can implement rules as they see fit, correct?
All right, let's take all three of those. So first, can a future administration or Congress, to get rid of the Affordable Care Act, either Section 1557 itself or the entire Affordable Care Act, Congress would have to pass a new law, both houses. So both House and Senate would have to pass a bill repealing it, and a president would have to sign it. So a lot depends on how the election comes out. A lot depends on who the president is, as well as who controls both houses in Congress and what the majorities are. I think people have seen over the last couple of years, it's hard to get even some must-pass legislation through Congress. So I would look to the fact that the ACA has been the law since 2010. There have been efforts to repeal it. None of those have been successful yet. So I'm going to remain optimistic that it will remain the law of the land. In terms of the regulations, if there is a change in the administration, they certainly can propose new regulations. According to the requirements for issuing regulations, there are supposed to be reasons to change regulations. There's something called the Administrative Procedures Act that sort of governs how agencies and the federal government can issue regulations. That's what requires the public comment process. So again, could we see a fourth set? Yes, anything's possible. It's going to depend on who's the next administration, what their priorities are, and how they want to move forward. The other piece I will say is that we have seen litigation challenging pieces of the rules in the past. There were challenges to the Obama regulations. There were challenges to the Trump regulations. There's already one challenge to these Biden administrations that focuses more on some of the sex discrimination pieces, but also wants to challenge the regulations as a whole. So, it is hard to predict. That said, I'd say even with some of the three sets of regulations, some of the language access pieces have remained consistent about having qualified interpreters and translators and bilingual staff. And so I certainly would hope that the recognition that we need to ensure effective communication would remain. Jorge, did I answer all three or did I miss
Yes.
something?
Yeah, no, I believe you touched on all three. I think the only outlying piece, and now it's disappeared from my queue, but it was whether or not the new administration could apply the rules as they see fit.
Um, the question of implementation and enforcement certainly varies by the priorities of administration. And enforcement priorities have certainly varied over the last 3 or more presidential administrations. I've been working in DC since 1998 at this point. So yes, that can change. And I think also depending on what's happening, you have other avenues of just bringing to attention issues that are happening at the state and the local level. Sometimes, you don't need the Office for Civil Rights to investigate a complaint, but raising some of the issues and egregious behavior that we've seen, whether it's filing a complaint with your insurance commissioner or talking with your Medicaid agency or your Attorney General's office, all of those have been effective in different states. As well as going to the media. So I think I would say that there are different opportunities, even if the focus at the federal level might not be where we would like it to be, depending on changes of administration and priorities.
So this
I
next
probably
question,
really sounded like a DC insider in that answer.
all right. So the next question comes from one of our language access leaders based in the state of Georgia. And she says, I have language access policies and procedures. Do I need a separate language access plan as well?
No, there's nothing in this regulation that specifically requires a language access plan. If your policies and procedures reflect all of the pieces of what's required under these regulations, then you shouldn't have to change anything. If you're missing any pieces, you may have to go back and amend or change or add something. So again, it's hard to know without, a very fact-specific inquiry. But what I think in general is if you've got pretty strong policies in place right now, just check with these regulations, see that they comply with all of it. So for example, maybe you don't have a process for defining who can be a qualified bilingual or multilingual staff. You got everything else captured. You've got definitions of qualified interpreters and lists of your translated materials. Maybe you're just going to need to add a section on that. So I think it is going to be very fact dependent on what entities have in place now. You may also need to add policies and procedures related to the auxiliary aids and services and communication for people with disabilities.
All right, so shifting gears a little bit, would workers' comp be included in section 1557 or under 1557? I'm not sure. The person asking says, I'm not sure the insurers receive any federal funding.
That's not my area of expertise. So yes, we'd have to go back and see, do they receive federal financial assistance? And I think that'll, I don't know. I don't want to answer that question and give you a wrong answer. So I think it depends if there's, federal funds that come in. Also, is it through the Department of Health and Human Services? So that would be a separate thing. It's probably more Department of Labor is my guess. And it would be up to them to sort of make that determination.
This one is somewhat related, so it might not be one that you can answer, but do you think this would apply to mental health co-responders, for example, a licensed clinical social worker that respond along with officers following a 911 call?
Here's my legal answer. I think it depends where they're funding is coming from. I think that there is currently funding from the Department of Health and Human Services through recent legislation to provide sort of the alternative response and the non-police response. So if that funding is coming from HHS for those social workers, even if they're responding with police officers, I would say they're subject to these 1557 regulations. If they're not receiving federal financial assistance, maybe your police department has just said it's important, or maybe there's state funding, then they're not going to be subject to 1557 per se. Again, it's got to be a health program or activity with federal financial assistance or a federally operated program or activity.
But they would be covered under Title VI.
They would be covered under Title VI, again, if there's federal financial assistance.
Right.
Yeah,
Okay.
so if they're right, so if the police department is funding them and there's no HHS funding, they still wouldn't be able to discriminate on the basis of language. But then they might be Department of Justice Title VI regulations rather than HHS Title VI regulations, not the LEP guidance from HHS. Every agency is supposed to have its own LEP guidance. They're available on lep.gov. And that's supposed to help inform their programs and recipients, since Title VI is, again, as we said earlier, all federal financial assistance.
All right. So in the same vein of funding, so a private hospital that accepts Medicare is required to comply with all of these regulations. Is that correct?
If Medicare funding touches that private hospital, yes.
All right.
I should have my caveat. I am a lawyer. I am not giving legal advice today. I'm just summarizing regulations. So there would still have to be an independent determination, but once those federal funds are coming into that hospital, even if it's a private hospital, then yes, it's going to have to comply with Section 1557 and Title VI.
Yep. Great. We're going to stay on the funding vein here. Healthcare interpreting is an unfunded mandate. Do the new rules change that in any way?
The new rules can't make any changes related to funding. This is a civil rights statute. That said, there is some funding available. States have an option under Medicaid and CHIP to help pay for language services. I think we're up to about 18 states that provide some funding. Medicaid managed care organizations are also supposed to ensure language access for services provided through those networks. Medicare doesn't yet have requirements for federal funding. We've been working on that for 20 or so years. We came close, but it's not there yet. But again, I would suggest taking a look at some of those statutes. Let's see. I'm gonna switch to this side so you can get my email. I guess I can't. We do have an issue brief. I'll try to post it in a minute or two. That talks about which states are paying for language services in Medicaid and CHIP, so that might also be a relevant resource for folks.
Great. Awesome. All right. So we've got a question here coming from Wisconsin. For the notice of availability in 15 languages, do we need to add them to each of the documents listed? So basically, are we adding one more page to each of those documents?
I don't think it's going to be 15 pages, if that's what you mean. So I think there'll be a notice of non-discrimination and a notice of availability. My guess is for a lot of entities, it's going to look similar to the tagline requirement, so that you'll be able to fit the 15 languages on one page. So if it's on that list that I had in the slide of which documents the notice of availability has to accompany, then yes, it might be a separate page. It might be posted in that physical location.
It would need to be added to each one of those documents on the list.
Yes.
Yes. Okay. Got it.
There's an opt-out provision that an entity can ask individuals with limited English proficiency if they want to opt out from receiving all of these. If they go through that opt-out process, yes, but the presumption is attach it to all of those documents.
Okay. Another somewhat sort of related question. Are there any example templates we can refer to for displaying both non-discrimination policies and language availability?
I believe that the Office for Civil Rights is going to come out with some of those templates in the coming months, and we can certainly make sure that folks get that. I think also they did have tagline examples under the previous administration. Again, this goes a little bit farther because it's also notifying individuals about auxiliary aids and services. So I think OCR has said it's going to develop those, and we'll just make sure they get around.
Another somewhat related question. Where did it go? Where can we find the applicable languages per state for the following requirement? Notices must be provided in English in at least the top 15 languages in the state.
Sure. I believe that's something else that the Office for Civil Rights is going to put information out on. Oh, none of my hyperlinks worked. Sorry, I was hoping I was going to submit resources. After the Obama administration regulations, they actually came out with a list state by state of the top 15 languages, and they also had translated taglines in multiple languages. So I expect HHS is going to do that as well, and we're just going to have to wait a little bit of time for that.
Got it. Must translated notices of discrimination appear in websites, or is this just a recommendation?
No, it must be on the websites too. So it has to be on the website, similar to it has to be on the paper documents.
Trying to keep these grouped in the same under the same topics. I think that covers all of those questions. So now, does the section 1515 person, the coordinator, do they need to have specific training to be in that position?
I don't think the regulations get into that. However, given their responsibilities, they have to have enough knowledge about how to evaluate and assess grievances and how to ensure the documentation. So I think it's probably going to differ a little bit. Again, one of the issues is that these regulations apply to such a huge swath of entities. Everything from a solo practitioner to a community health center to a giant hospital to an insurer. So the regulations sort of don't always get into the details of what it means for all of those, right? Because it's going to look very different if you're a 15 employee practice versus, a large insurer, what you should be doing. So some of it is, again, I think as we move forward and these regulations are implemented, there's likely going to be some more information coming out from the Office for Civil Rights and some more guidance and maybe some frequently asked questions, things like that.
Then this one I just saw it in the chat out of the corner of my eye, so it's kind of related to what we're talking about. Like the past 1557 regulations, if a healthcare entity can prove that the top 15 languages are different than the ones listed on the HHS website, can we use those top 15, the ones that the healthcare entity has identified?
I certainly think that will be the case, yes. I don't see any reason why not.
All right. So switching gears a little bit, I think this is an interesting question. Is a clinic acting illegally when they ask the patient if they need an interpreter?
Okay, first of all, I'm not going to give any legal advice. So I just want to be really careful with that. But if they're asking if they need an interpreter to identify if they have to provide language services, I would say that actually is something they should be doing. So I'm a little unclear. I don't know if there's different context or something that I'm not understanding.
Yep. Okay. We'll move on. See, these all seem to be in the same. Okay, so let's start at the top. I'm wondering what criteria is considered best practice to meet the definition. Question moved on me. Where did it go? Okay, I'm wondering what criteria.
Sorry, moved into answering it live.
It's okay, Sean. Is considered best practice to meet the definition of qualified translator that isn't the ATA certification because it is so difficult to place. What criteria is considered best practice to meet the definition of qualified translator that isn't ATA certification because it's so difficult? All
right, sorry, hold on. Give me 1 second because I'm having a hard time talking and pasting at the same time and my link didn't work. So now my link is working. Okay. The regulations don't talk about certification. So they don't say you have to be certified to be qualified. They use the term, what's a qualified interpreter or translator? So I just want to be really clear about that. To me, I would say if someone is certified, it should document that they are qualified. But you don't have to have ATA certification. You don't have to have CCHI certification. If the entity has another way of showing that someone is qualified, that's going to be sufficient. Again, what does this mean in practice? Well, OCR is not going to go in and look at every single hospital and healthcare provider's processes for determining qualifications. But if a complaint is filed because someone isn't getting effective language access, then they may come in and take a look at it. So I'm not sure that exactly answered the question.
Yeah. Yeah, no, I think that's clear. So along those same lines, does the federal government provide any tools or resources to help entities measure language proficiency to determine qualified bilingual or multilingual staff?
I don't think so. I mean, there's some information and guidance and resources on lep.gov about, things to think about in developing language access policies or hiring contractors or things like that. But this is where the federal agency really isn't getting into the minutia of how, what is the right way to determine qualifications for these.
Right. Along those same lines, for these qualified bilingual staff, is interpreter training specifically mentioned in the new regulations?
Okay, so for qualified bilingual or multilingual staff, they wouldn't have interpreter training because they're providing services directly in a non-English language rather than serving as an interpreter. So that's one thing. I'm not sure that was the nuance there.
Yeah.
I think the regulation doesn't get into anything about interpreter training or translator training. So, I think for CCHI, we've said you have to have at least 40 hours of training to be eligible to sit for certification. The regulations don't get into that level of detail.
All right. Quote unquote, is able to interpret / translate seems weaker than, quote, has demonstrated proficiency in the language proficiency part. Is that your take as well? Do you think people will test only for language proficiency or lean more heavily towards that since the language does not specify demonstrating ability?
Someone's reading into all my slides. I'm trying to get back there and see. And it may have been how I framed it on the slide, to be perfectly honest. So, that gets really specific, but I think it has to be, sorry, I'm not finding it quickly.
This came in pretty early.
Yeah, definition, has demonstrated proficiency and is able, these are, they're ands. You have to have all of them. So you have to demonstrate proficiency and be able to interpret effectively. So to me, I would say a language proficiency test alone is not enough because you don't know if that person can interpret. And you don't know if they have the, ethics and principles and things like that. So I'm not sure that exactly answers it, but I tried.
Right. In my policy, rather than naming specific qualified bilingual staff, could I refer to where to find that information?
That's a level of detail I just don't know. The regulations say you have to have a list. I think someone raised with me earlier, not on this webinar, but I've been talking a lot about these regs. That list can change so often. So what happens? Again, I think that's just a level of detail we don't quite know. I would try to comply with what the regulation says and have that list in your policies and procedures. Maybe it's an appendix so that if it does change, you can just, move it quickly. But I do think the idea is to make sure that there's an awareness of the entity from the entity that you can't just assume anyone who says they're bilingual is going to be qualified.
All right. We've got a couple of AI related questions. The first one is, are there any updates regarding AI interpretation?
Not in this regulation per se. So I know that there is an AI safe task force that's working on this issue, and I'm pretty sure CCHI participates. That's not me. The National Health Law Program does a lot of work on AI sort of more broadly. I'll paste when I'm done talking a website that you can take a look at for some of that. But I don't know, Jorge or Natalia or someone else, if you want to address if there's anything more specific about the AI task force.
Yeah. I mean, I think that was the question was related more to 1557. So I think that's
Okay.
I think you answered that part of it. So another question that came in is, can we use AI text to speech apps to produce audio files for the blind and visually challenged patients?
Hold on one second. I'm typing and
Yep.
can you use AI? AI
Text.
or do you mean automated translation?
Well, it doesn't, I don't think that this is addressing a language barrier because the question is related more to persons who are blind or low vision.
Got
So it sounds like they're using some sort of text to
Oh, a
speech
text to
app.
speech or something. Okay.
Yeah.
Um, I'm going to be honest, that is beyond my knowledge. I've got colleagues at the National Health Law Program who focus a lot more on protections for individuals with disabilities. The Section 1557 reg has some of those, but they're also almost at the same time the 1557 regulation was released. There were updated regulations implementing Section 504 of the Rehabilitation Act, which is kind of similar to Title VI, which says if you take federal funds, you can't discriminate on the basis of disability. So those regulations were updated for the first time in decades. So I'll put my email in the chat and feel free to email me and I'll see if my colleagues happen to know.
All right. All right. Um, Mara, can you speak about malpractice insurance not covering providers when they do not use proper language assistance services?
Okay, so we did a report a number of years ago. I'm going to start with that about the high costs of medical malpractice, high cost of language barriers in medical malpractice. And again, I'll try to paste that in the chat. The specific question about if a provider doesn't use effective language services, are they covered by their malpractice insurance? I can't answer that one because it's going to depend on the text of the malpractice insurance. So it's very fact specific. That said, my understanding is that a lot of malpractice insurance requires the person covered to comply with all applicable federal statutes and regulations. So in that case, you could make the connection to say a provider who doesn't use a qualified interpreter and therefore there's errors or problems or malpractice could run into issues. I'd say that's an open question and that's really up to the malpractice insurer to determine what's going to happen. So thank you, Jorge, for posting that
Yep.
link.
Yep.
But I think that's a little bit harder. We would love to dive more into this. The report that Jorge posted is got our toes into the water. And we just haven't had the resources to be able to sort of follow up. But I do think it's a very interesting issue. And it's certainly one we've been wanting to dig into more.
Okay. All right. So we've got a few more questions here. These are some more, for instance, type of scenarios that folks have asked questions about. So the first one, what happens when the patient does not want an interpreter and prefers to have a relative interpret? So they don't want a professional interpreter, prefer to have an ad hoc interpreter.
Sure. I think in those situations, again, one, the entity should be documenting that the person, is declining to use an interpreter from this facility. But second, from a risk management perspective, unless you know that adult meets the definition of a qualified interpreter, I still think it's the responsibility of the covered entity to ensure effective communication. So some of it is why is the person saying they want to have their family member, I'm just going to say that, family member, friend, advocate, faith leader, whatever, interpret. Sometimes it's because the patient doesn't understand that they have a right to an interpreter that will be provided timely, free of charge, competent, etc. So that's one thing, is to make sure that you're explaining to the patient why you are providing language services, that your care is not going to be unduly delayed, that you have to provide meaningful access. Second, they may be concerned about confidentiality. If they come from a small language group in a small town, they're worried about the interpreter knowing them or violating confidentiality. Again, explaining confidentiality is required. Maybe in certain circumstances, I've heard of them not using an in-person interpreter, but going to telephonic or video, so it's not someone from their local community. That can allay fears. Third, again, I think, again, from the risk management perspective, it's still the responsibility of that covered entity to ensure effective communication. So having their own interpreter in the room or on the phone or whatever the modality is to ensure that there's effective communication, sometimes what will end up happening is the interpreter is going to have to intervene and make sure that there's an understanding that this family member or friend is not accurately interpreting, is leaving out information, is misconstruing it, whatever. And sometimes in those situations, it's important for that interpreter to intervene. So again, it's kind of fact specific. I think also mentioning to the accompanying adult that they can remain in the room as a support person, as an advocate, to help with decision making. They don't have to serve as an interpreter, and their role actually may be better suited to play those other roles. So I do think those are some of the issues to explore, is to make sure that the patient is informed of their rights, that someone's actually explaining what the requirements are on the entity, and that a qualified interpreter explains that, and then still to have a qualified interpreter as backup, because if inaccurate communication is happening, that entity is still going to be on the hook. Do they have I forget what I said, there's what it said, did the entity have reason to know that adult wasn't sufficient to use? Like, is that adult here's the word, appropriate under the circumstances? And if they're not appropriate, that covered entity could still be on the hook if something happens.
All right.
Sorry, a little long-winded.
Is there any? No, that's perfect. I think it comes up a lot, right? So I think it's just a good time to cover that once again. Is there any recourse for self-pay LEP patients who are turned away from specialty care, for example, neurology, because they don't offer language services and the patient didn't bring one to the appointment? Self-pay.
Okay, you're getting into my lawyer stuff. It depends. So, does that neurologist or specialist take federal funds? So
Right.
if that neurologist takes Medicare and sees Medicare patients or Medicaid patients, they can't turn away a self-pay patient and not provide language services just because they're self-pay. Once those federal dollars touch that practice or that entity, it applies to everyone in that entity, regardless of insurance or self-pay. If that neurologist truly is not participating in any health program whatsoever, then they can turn someone away because they're not subject to this law. But again, it's kind of rare that would be the case.
Yeah, sure. All right. For primary providers that have a direct speaking role with a patient without the use of an interpreter, or without the services of an interpreter, let's say, in a language other than English, should their language proficiency be validated as well?
You're getting into the details of what does it mean to be a qualified bilingual or multilingual staff.
Mm-hmm.
So again, it's kind of like, it depends, right? Would a language proficiency evaluation help show that they're proficient in speaking and understanding? Yes. Is it the only way? No. So it doesn't say you must do language proficiency assessments. It doesn't say that. It just says you have to ensure that the qualified bilingual or multilingual staff is proficient in speaking and understanding, including any necessary specialized vocabulary, terminology, phraseology, and able to effectively, accurately, and impartially communicate. So what that means in practice, it depends. If it's a bigger entity, I'd say it can't hurt to have that language proficiency testing, and some entities do that. We've certainly seen a qualified bilingual staff model where they actually have to have that language proficiency assessment. But it's not the only way.
All right. All right, Mara. Well, I think we've come to the end of the queue of questions. Really want to thank you for all of this information today. We've posted the links in the chat, both for the resources that are available on the NHelp website. We also posted links to our YouTube channel, our social media. So keep an eye on those, as we'll be posting announcements when the recording of this is available. This will be a great video to share with your risk management folks, with your compliance folks, with all types of other departments and leadership in your organizations. So please bookmark it and keep sharing it. And Mara, thank you again. Really, this has been really, really informative. A lot of information, and we're so grateful for you breaking it down for us.
Thanks for having me, and look forward to working with you all as we really work to make sure this is effectively implemented and enforced.
Absolutely. Thank you, everybody, for joining us. Y'all have a great rest of your day, and we'll see you at the next CCHI webinar. Bye.